Good afternoon. I am Kelly Brown Douglas, Dean of the Episcopal Divinity School at Union Theological Seminary here in New York City. I'd like to welcome you all to this conversation on understanding Fulton versus Philadelphia. As perhaps you all know, in a unanimous judgment on June 17th, the Supreme Court ruled that Philadelphia's refusal to refer children to Catholic Social Services Agency for foster care, they complied with non-discrimination requirements, namely the Catholic agency's policies regarding same-sex couples did not violated the free exercise clause. Now, this ruling is more complicated than perhaps it appears on the surface, as both sides of the debate have declared that the narrow decision is a victory. And so we have with us today, to help us understand the meaning and implications of this decision, three people who bring with them expertise as well as a long record of human rights, social justice advocacy, especially for children and LGBTQ+ persons. Joining me today is Daniel Gerard, Senior Staff Attorney at Children's Rights, the only organization in the United States dedicated solely to turning dangerous child welfare systems into safe havens for kids in need. Also joining me is the Reverend Stan J. Sloan, Managing Director of Collegiate Churches of New York and trustee for Union Theological Seminary, and former CEO of Family Equity, the nation's leading nonprofit for LGBTQ+ families and those who wish to form them. And then rounding out our panel is the Reverend Patrick Chang, theologian in residence at St. Thomas Church, Fifth Avenue in New York City, adjunct professor here at EDS at Union, and prior to his work in the church, a practicing attorney. He is also a queer theologian who has written many books and one, Radical Love. I thank each of you for joining us today in this important discussion. So before digging in to the issues and implications involved in the Fulton versus Philadelphia decision, Patrick, if I may, let me begin by asking you, how did we get here? Can you provide us with a brief history of the road to last week's decision, especially for those who have not followed the case closely and those outside of the legal world?
Sure. Dean Kelly, thanks for having me here, and it's great to be part of this wonderful panel. Yeah, just in a nutshell, as you described it, even though it was a 9-0 ruling and the headlines sort of the Supreme Court rules in favor of Catholic social services, it was very much a more complicated decision. And in particular, what's really interesting, I thought, was how the decision was split 6-3. 6 justices in favor of not overruling the Smith case, and 3 who wanted to. And to me, that's the central issue here. So for those who are not familiar either with the decision or legal matters, the Smith case was decided in 1990 by the late Justice Scalia, which was funny because it was decided the spring before I started Harvard Law School. So when I went to law school, everyone was all abuzz about it because it had really turned over decades of free exercise jurisprudence. And free exercise is the clause in the First Amendment that prohibits the government from inhibiting the free exercise of religious organizations. And in a nutshell, I think what Justice Scalia had done was saying that basically neutral and generally applicable laws, right? Just general laws like non-discrimination laws, as long as they don't target a religion or have individual exemptions, the state can pass those laws, right? And so, back then, it was really the conservatives that were for Smith because that involved Native Americans who had ingested peyote as part of a religious service. And they were terminated because they were sort of recovery counselors or something, and they were denied benefits, unemployment benefits, because there was a general law prohibiting the use of psychedelic drugs, right? But several decades later, I don't think any of us would have imagined that these neutral laws are now non-discrimination laws. So it's really the liberal side that wants to keep Smith there. So in a nutshell, does that help, Dean Douglas, just to set the ground? Yeah.
Yes, indeed. And of course, what we found in Philadelphia was that the city said that the Catholic Social Services were violating their non-discrimination laws by refusing to allow same-gendered couples to apply for foster care. And of course, the decision by the court was that, well, the Catholic Services, in fact, can indeed follow their religious freedom, if you will, to not accept because of the way in which the city had written its contract, right? And so allowed for this, the city of Philadelphia, in fact, said that there could be exemptions to the law. And so the Supreme Court said, well, this is a particular exemption and based fully on the way in which the city had indeed written its contract. But this leads me to ask you, if I may, Danielle, that the ruling basically means that at least for now, Catholic Social Services can refuse to work with LGBTQ plus families who want to open their homes to kids in need. Yet many, including the ACLU, as well as your organization, Children's Rights, saw the ruling as somewhat of a victory in spite of that. Can you explain to us why?
Well, you know what kinds of times we're living in, so that explains part of it. Look, the Fulton case was a tough loss, okay? We can't deny that it was a tough loss, especially for Philadelphia's LGBTQ potential foster families and the children who were essentially being told that they're not valued.
Yep.
And the creation of stigma is very, very hurtful. But as you've said, Dean Kelly, and I should have started by thanking you so much for doing this panel. And I want also to thank Union Theological Seminary and the Divinity School, not only for arranging the panel, but for being founding members of the Interfaith Coalition for Children's Rights. Your work and participation have been invaluable. And the fact that you're hosting this panel is just one part of that. But regarding the decision, it was a tough loss, but it was a narrow loss. We are so relieved that it wasn't worse. It could have been much worse based on what the concurring opinions had to say, but it was a narrow ruling that applies specifically to the contract at issue in Philadelphia, as you've described. The court did not create a broad license to discriminate based on religious beliefs, nor did the court upend longstanding First Amendment jurisprudence that requires faith-based entities to follow laws that are facially neutral and generally applicable, as Patrick described. And I will say this: there were a couple of throwaway lines. The court did recognize that the city's interest in enforcing non-discrimination protections for same-sex couples was a weighty one. They actually said it was a weighty one. So what the court did instead, and the reason that the advocates and the legal community, the right-thinking legal community, are talking about that this was a narrow loss, is that the court seized on the ability of the Child Welfare Commissioner to grant individual discretionary exceptions from a clause in the contract that states that a provider can't refuse to accept the child or family for placement. Now, for those of us in the child welfare field, I'll explain that in a minute, but what the court focused on, and this is really important to understand, is there was a clause in the contract that says a provider can't refuse to accept a child unless the commissioner grants an exception. that was not the broad non-discrimination provision in the contract, for which there were no exceptions. It was a broad non-discrimination contract, but what the court did is it conflated the two and said that the existence of the exceptions that the commissioner could grant regarding placing a child in a home meant that there could be exceptions to the broader provision, which actually allowed for no exceptions. But this is what the court said made the contract not generally applicable, going back to what Patrick said. And I can expand on why this wouldn't make sense when you look at it from the child welfare perspective, but it's also, this is a gift horse that made this a narrow loss.
So I want to follow up on that and first do so with Stan in this regard, because on the one hand, we could talk about the way in which the city of Philadelphia needs to rewrite its contract, and that there was a loophole in the contract itself, that they allowed for some room for exceptions. And so at the same time, that allowed for the narrow ruling in this case. It also, Stan, and I turn to you. On the other hand, there are those who see this ruling as a victory for religious groups and a setback for LGBTQ plus rights, and further evidence that religious groups can indeed find a way, as in this instance, the Catholic Social Services Agency did. They can find a way to use religion as a tool to discriminate, and that in fact, the ruling in this case at least leaves open the possibility to do that, poor contract writing notwithstanding. Your thoughts?
Yeah, so to that point, I think that, this really just kicked the can further down the road.
Yeah.
And we still have yet to see what this court will do. And it's frightening. For queer organizations, it's frightening. So you've got two attorneys here, or two people who are much better at law than I am. But I'm a former Catholic priest, so I at least have that perspective. And I just can't tell you how offensive I find it. And the fact that the right-wing conservatives would consider this a victory is similarly offensive. I think the Catholic Church has historically found itself to be on the wrong side of civil rights movements through the ages. And I think history will prove that again in this case. But for me, the most disturbing thing is that it broke, their philosophy breaks the cardinal rule of child welfare, which is do what is in the best interest of the child.
Right.
63% of young queer millennials plan on forming families. As everybody knows, we have less opportunities to do that. So foster care and adoption systems are horribly important to us. And the fact that there at this moment are over 500,000 children in the child welfare system who need homes, and that LGBTQ people have the depth to be able to provide those homes, and that Catholic Charities feels like that not providing those homes is in some ways consistent with the gospel, again, is very offensive to me. And I'll say one more thing and then shut up. And that is that while Philadelphia Catholic Charities may be able to say, well, we refer them to other agencies, queer people exist in small towns, in rural areas, and other places won't have the option of being referred to another place. And so what you will have is our children without homes, and you will have loving parents denied the ability to form their families.
No, well said. And Stan, I want to get back to, in a minute, this sort of the theological basis of all this, because as we are all responding in some respects to the legal and to the political, there's a theological there, and then in this issue of faith communities' role in all this. But I want to pick up on something that you ended with, and perhaps direct this, have Danielle start us in this discussion and have you all weigh in. And this is what we do know, that LGBTQ young people are overrepresented, right, in the foster care system. They are also more likely to experience discrimination, abuse, neglect, and the risk of harm. We've also know that 78% of LGBTQ youth were removed or ran away from foster homes because of the hostilities they faced, right? And 56% of those choose to live on the street. And I hope people listening take in these statistics. 56% of those choose to live on the street rather than in a foster care placement because they felt safer on the street than in a foster care placement that did not respect the sacredness of who they were as human beings. So Danielle, I want to start with you because Children's Rights has a mission for keeping kids safe and healthy. How do you do that in relationship to perhaps religious beliefs like those put forth by CSS, or seem to function to the contrary of keeping children safe and healthy, and therefore limiting, as Stan has pointed out, the options, especially for LGBTQ plus youth who are searching for safe haven?
Yeah, so I mean, I think you've already talked about everything that's important here, and so have Stan and Patrick. But this is what I was referring to before when I talked about the stigma, because this does trickle down. And our lead counsel at Children's Rights on the LGBTQ matter, Christina Remlin, did a report a few years ago and spent a lot of time speaking with LGBTQ youth in care. And it is really important, of the utmost importance, to have affirming adults in their lives. And so the problem here, and I won't talk for too much longer, but the problem here, and Stan touched on this a little bit too, it's not the correct analysis to say, well, if we refuse you, if Catholic Social Services refuses you, well, we can just refer you to another agency. The prospective foster parents or mentors have already been stigmatized, and this trickles down to youth. And some of the laws, as you referred to earlier, Dean Kelly, at the beginning, some of the laws that are being passed are going to be harmful to children. And this is not what we are supposed to be doing, whether under a theological framework or in the child welfare framework, where we're supposed to be focusing, as Stan said, on the best interests of the child. But I want to make sure for this crowd that when we read about this stuff, although it seems like the right was very excited about this opinion, one of the attorneys had a piece in the Wall Street Journal the next day that made it very clear that they were actually disappointed with the ruling. You have to read a little bit between the lines. And I just want to say one more thing about this, and then I'll turn it back to you, is that, you know, we're all reading and hearing that the case, you know, discussing the case in terms of pitting religious beliefs against LGBTQ rights and what a victory it was, et cetera, but that's not the correct analysis. The correct analysis is whether agencies can take taxpayer funds and discriminate based on religious beliefs. And the reason that we know that this supposed fight between religious beliefs and LGBTQ rights is not the correct frame is because, first, many LGBTQ people are people of faith.
People of faith, that's
I know that lots of people of faith believe in LGBTQ equity. We also know that there are faith-based organizations doing foster care work without regard to LGBTQ status. Specifically, one of the largest and oldest evangelical providers, Bethany Christian Services, has publicly declared it's not going to turn away same-sex couples. And finally, these faith-based providers who believe that they can discriminate based on religious beliefs have turned away Jews and Catholics from being foster parents and mentors. So they're discriminating against other religions. And this happened in South Carolina. And now I'll stop talking.
No, don't stop. So Patrick, let's do some follow-up on that.
Sure.
My goodness, Danielle, you gave us a mouthful and you challenged, and that's good. And because it challenges certain segments of the religious community, right? And what sort of the progressive religious community, and Stan says, you know, he's offended by this, and many of us are. And Patrick, let me turn first to you in response. You do theological work and have done this work for a long time in terms of advocating for human rights, but particularly from the perspective of those in the LGBTQ plus community. What are we to say about this? We know, even as Danielle has graciously pointed out, that there are others within the faith community that don't support the sort of the beliefs of what we may call the religious right in this regard. But that's, you know, those others haven't been the loudest voices on the public square. What do we say theologically? What can we say to our stance as the Catholic Church has come down often on the wrong side of this? What do we say to our Catholic siblings and to others? And what do we say to LGBTQ plus persons who find themselves trapped within religious settings that deny their very sacred humanity? So I'll start with you, and Stan, anyone else can jump in.
Great. Yeah, thanks, Dean Kelly. I think Danielle made a really good point about the false dichotomy, right, between religious freedom and LGBT rights, because there are those of us that believe in both. What I would like to say to the audience, and in response to your question, is that there are a number of fascinating amicus briefs, right? These are briefs that supporting organizations have filed. There were over 40 in favor of the city of Philadelphia, over 30 in favor of CSS. And I couldn't be prouder as an Episcopalian of at least 3 briefs, right? One of which was EDS and Union. Sort of the focus of that brief was exactly best interests of, you know, children, and the fact that there are LGBT foster care, you know, kids as well as parents, right? So that amicus brief dealt with those issues. But Gay Jennings, the president of the House of Deputies of the Episcopal Church, joined an amicus brief that talked about the religious left and how there is many denominations that affirm the inherent goodness of LGBT people, right? And we could talk theologically about, you know, made in the image of God, Imago Dei. You know, we could talk about, you know, sort of orphans and widows, you know, but I think, you know, just for everyone, I commend to you that you look at these briefs. And the third one is from the presiding bishop, right? Presiding Bishop Curry actually joined a brief saying that even though they disagreed with Smith, they believe that non-discrimination actually helps religious liberty. Because if you think about it, like, you know, what if you had a soup kitchen or a food pantry? And if every sort of religious organization could have the right to veto it, what if they said, all right, we're not going to feed people who are, you know, of non-Christians, right? I mean, when does this thing end? And you have all this COVID litigation by churches saying that we have the free exercise not to listen to the state. And then the last thing with Roman Catholics is there's a great amicus brief by 27 Catholic lay folks that actually set out why they think Catholic teaching actually supports the city of Philadelphia. So I just say this is a fascinating intersection between law and theology. And anyone, you can Google amicus brief Fulton, and you can call up those wonderful briefs.
So what you raise here, yes, is that the religious freedom sort of clause, if you will, can function as a blessing or as a curse, right? And so how do we prevent sort of this slippery slope? How should we be thinking about this clause? And I see, Stan, you shaking your head on this. At some points we want to say, yeah, it's about religious freedom, and at other points we say no. So how should we be thinking about this?
Yeah, so again, for me, it's really frightening. And again, this is how the can got kicked on further down the road. So family equality worked very closely with Congressman John Lewis around this subject. And Congressman Lewis saw religious liberty as the biggest threat to civil rights in our time. And so, as Patrick mentioned, this does go much bigger than the child welfare system. And already, so having worked with homeless communities that were LGBTQ, the discrimination happens every night in the shelter system for trans women, for trans men, for queer people of all types. So again, it is extremely disturbing, and the family equality has the Congressman John Lewis, Every Child Deserves a Family Act that would end discrimination in the child welfare system. Because if SCOTUS is shown to take a right turn around these issues, we are going to need the two other branches of government to step up and to protect the kids in the system and to protect queer people who want to form families.
Well said, and and leads me to another question. I want to combine it as well with the question that's in the chat that was directed toward you, Patrick, but Danielle would ask you to answer it as well. Someone has asked if Philadelphia changed the contract, would this fix the situation? And hearing both Patrick and Stan speak to this, I'm also struck by the fact and wonder, if it wasn't about LGBTQ plus persons, I wonder what then the decision would be, because what if this organization said, no, we don't want interracial couples to adopt because that's against our religious beliefs, interracial couples doing the same. And so it makes me wonder, while we know all these things interact, these discriminations, but that what is making it more acceptable theologically or otherwise to discriminate against anybody but LGBTQ persons, let alone children, than it is to discriminate against people on the basis of race. And so that's one question that I combine. And would fixing the contract solve that? And would SCOTUS have said something different if indeed Philly did not leave that loophole of exceptions in the contract? So I'm going to direct that to both Patrick and Danielle initially, and then any of you can jump in. Danielle, yeah.
So I just want to say that all of what you just asked could be the topic of a panel. So I want to say something about your focusing on the contract first. And that is that Alito specifically recognized that. He said, this decision might as well be written on the dissolving paper sold in magic shops. Okay, so he recognized that all Philadelphia has to do and all the other organizations have to do is take out that exception. And again, I just want to caution us that it wasn't the right non-discrimination provision that they were all talking about. And they conflated them. Again, that gets back to what I said, that we shouldn't be looking a gift horse in the mouth, because that kind of sleight of hand allowed the court to broker a decision to decline to authorize much much broader discrimination, which gets to Stan's point about this being much bigger than child welfare, because if they had gone the other way, it would have affected soup kitchens, and it would have affected homeless shelters, and it would have affected a whole bunch of other things. I also am really grateful that Stan and Patrick are raising the Equality Act and the John Lewis Every Child Deserves a Family Act, because that is what we need to focus on next. But I want to address your other question by pointing out that when Children's Rights filed its amicus brief, we had over 40 people on, and we had 8 members of our interfaith coalition, including Union Theological Seminary and the Divinity School, and a number of other people, which is a roundabout way of my trying to answer your other question, which is that it seems like what's going on, and Stan and Patrick, I will stop talking so that you can answer this, is that it seems like what's going on is religious freedom arguments are being used to dilute equality rules, that what we're heading toward, this sort of anti-religious bias, is being used by government to turn any claim of discrimination into an attack on Christianity, and that the result is that non-discrimination laws must yield to religious objections. And I'm just going to take one more nanominute to answer Dean Kelly's questions about what if people were trying to discriminate against people of color or some other group. This has been tried. There are 2 Supreme Court decisions where the court rejected arguments that an owner's religious freedom would be violated if he had to serve Black customers. And there was another decision where the court denied universities the right to refuse admission to Black students or those who advocated for interracial dating on religious grounds. And finally, there was a 4th Circuit case, which, if you can believe it, was in 1990, saying religious schools did not have the right to pay women less because their faith taught them that men should be heads of households. So what's been going on here, it seems like, is there is a distinction between failed efforts to use religious liberty to undermine Civil Rights Act or women's rights, and successful efforts to use religious liberty to undermine Roe v. Wade. And now we're seeing, and this is why I'm calling it a very narrow decision that could have been worse, we're seeing something that could have really opened up the same discrimination against LGBTQ rights in general, and didn't, because this decision only applies narrowly to the contract. I'm done.
No, so Patrick, I'm going to let you jump in and just add something, because Stan has been saying this and you've said this as well, that it seems like then we're just kicking this issue, as you said, kicking the can down the road, because in Gorsuch's opinion, and this is a question in the chat, he argued that the majority judgment was legally weak and really forestalled reviewing the Smith decision, which the 3, Clarence Thomas, Alito, and I can't remember the 3rd, suggested that needed to be overturned. So
Yeah.
so here we are. This is to the point that you have all raised, and Danielle has raised this point about making these decisions about religious liberty. So your thoughts?
Sure, and it is sort of Alito and Thomas and then Gorsuch. I think Danielle is right that, in theory, you could amend the contract, and Justice Alito was very upset about this magic paper thing, and Justice Gorsuch also said, not only kicking down, he's like, you're just going to start all over again. They're going to do that, and then you're going to come back to the court. So why do all that? But I will say that one interesting thing is this almost happened. The same thing happened with the Masterpiece Cake Shop case that was decided some time ago, where the baker in Colorado would not do a cake, right? That he offended his religious beliefs. And basically, the court also came down on that side, but in a very narrow decision, sort of said that, because of animus, stuff that the commissioner was sort of saying, that violated the neutrality provision. And my point is that the court, even though it is scary, I do think in both cases did not have the appetite to overrule the precedent. Not to say that it couldn't happen, but I think that's one thing. And the other thing I just want to mention with theology is the whole notion of intersectionality. In the legal sense, you have this hierarchy that race is here, then you have gender, and then disability and sexual orientation. But that sort of in theology, we think about, the intersections, right? It's not these discrete categories. And so I think there is some, an issue with thinking along those lines as to which oppression is higher than others, right? So I would just sort of name that too as an interesting issue to think about.
Well, and this becomes the role of perhaps the church and public theologians to make clear, right, the sacredness of all humanity, and that oppression is sin, sin is sin. And so there's no oppression that's higher than another. All oppressions are sinful. And so and discrimination is sinful. And so again, it just takes us back to this question of what the role is of faith institutions in sort of on the public square in terms of these political matters, because it continues to take us back. Stan, your thoughts on this before I take us further down the road in terms of the Equality Act?
Yeah, so just, make no mistake. I mean, they are using religious liberty as a weapon. And we really need strong religious liberty laws to protect minority religions. So religious liberty is getting a bad name in the bigger picture, and yet, Danielle mentioned, that we're diluting, equality rules through this, but also what we're doing is we're legalizing discrimination. Right, in the name of religion, and for queer people, like if that can eventually gets kicked down the road by SCOTUS with Smith, what we will clearly be saying is that even our marriages and marriage equality, our marriages are not equal, right? And so it's frightening, and it would be explosive on civil rights in general if they would make that decision.
So this leads us then to the Equality Act, right? Some have said and argued there's no need for the Equality Act. We had the courts ruled on Bostic versus Clayton in Georgia, right? That said an employer who fires an individual merely for being gay or transgender violates Title VI. You all know more that than me, but is a civil rights violation. And so the question becomes: so why do we need the Equality Act when we already have the courts have already ruled on this matter? Yet we see that we have a record number of laws being passed or trying to be passed on state and local levels discriminating against LGBT communities. So I'm going to ask, why do we need the Equality Act? Even as we recognize, and it's in the news today, that it has passed in the House, which it did some time ago, but the chances of it passing in the Senate are getting slimmer and slimmer. So anyone can jump in on that, why we need it, and what you think of the chances of passing it, and what can we do to try to get it passed?
I'll be brief, but I'll start. So for the last few decades, queer people have looked to the Supreme Court to advance our rights because the executive and the legislative branches were less likely to be favorable. Looking at the makeup of this court and this can getting kicked possibly down the road, we need this legislative branch to step up. We know, I mean, had Trump won, right now what would be coming at us from the executive branch would be formidable. Thank God, you know, Biden is reversing a lot of the bad policies, but we're going to need that branch of government to step up, and the Equality Act will do that and get that established for us.
And I guess I should mention that the Equality Act expressly states that one cannot against LGBTQ persons. Daniel, it looked like you wanted to jump in.
And I think what Stan said is exactly right. And we need to get the Equality Act passed, and then we need to get the John Lewis Every Child Deserves a Family Act. There are not that many differences between them, but the Every Child Deserves a Family Act does say that you cannot discriminate on the basis of religion. And that is really important to this whole dialogue. You know, I do want to say that I think that I mentioned this earlier, that the correct analysis is whether faith-based agencies or any agencies can take taxpayer funds and discriminate based on religious beliefs. You know, I'm not going to say it'd be, you know, okay if they were only privately funded, but it's really, really not the road we should be heading down. And I think that we really need to bring the analysis back to that you cannot take public money and discriminate, period. So I think that that's something that the court, and Patrick explained this earlier, what the court did, you know, as a general matter, when a local or the federal government gets a deference for its laws, and if there's something wrong, which the court said in this case, then it has to be looked at with strict scrutiny, and which just means a rigorous analysis. And this is all well and good if what we were talking about was using taxpayer funding.
Yeah.
I think that's something that completely got lost here and wasn't addressed by any of the opinions.
So it leads me to follow up with you, Danielle, with a question that someone in our listening audience or watching audience has posed, and that is there a difference between feeling discriminated against or discriminating against someone because you disagree because of your beliefs and being discriminated against because of who you are? We may be able to make a theological difference in, is there a legal difference to be made?
So discrimination is wrong, period. It doesn't really matter what your motivation is, but it's particularly wrong when it's publicly funded. And I really think that that's something we cannot hammer home enough. And I just want to refer again to the cases that I mentioned that said you cannot use religious belief to discriminate in any of these situations. And Stan said it, you know, this has been weaponized. These are not reasonable interpretations of the First Amendment. They're just not. And one of the things I learned in law school is that the Supreme Court is not always right.
Well, but that too is scary, right? I mean, even when you're talking about overturning a precedent that is Smith, and some may think, yeah, it needs to be overturned. But there are other precedents that the Supreme Court has established that we don't want them to overturn, right? And so it begins to depend upon the nature of the bench. And not right now, we're in scary times with the nature of the bench that we have. And so in many respects, that's why the Equality Act becomes important in this regard. Patrick.
Yeah, and I just wanted to highlight, you know, just in terms of the debate, I think legislation is important. And there are certain things, though, that only the Supreme Court can address, right? So the Congress tried to address the Smith case. And in one of the cases, it got struck down because they said that you can't legislate, freedom of religion or free exercise. But what I will say, though, is that I think what we need more of is debate and public theological discourse. You know, far from me to say what another denomination should believe, but I have every right to say what I believe. And frankly, so much of that only occurs within seminary walls and within sort of religious organizations as opposed to the public square. And I think that is something that comes out of this that I think is very important. And the last thing is just, this whole government contractor thing. Like what happens if you have a fire person who refuses to put out a fire when a gay-owned shop is burning? Or, the hospital case in terms of someone who won't treat someone who's trans. I mean, just certain contracted jobs, they don't have a right to. If you want to get money, my understanding is CSS gets $26 million a year. Here they are saying poor, they're so discriminated against, but in oral argument, it was pointed out that they get $26 million a year, and they're arguing they want 13 to 15 million more or something on the certification front.
Which again goes right to Daniel's point, right? And that there's a different issue here, and perhaps a more significant issue that we're missing, and that is if organization that discriminates has a right to get taxpayer funding. And it seems to me if one rules on that, then it solves some of these other issues. But this leads me to ask this question. My goodness, the time is going. So I want to ask two more questions. And this is this, we find ourselves, now we're in this discussion and there are people on both sides of this issue. We find the Equality Act basically stalled in our legislature right now because people can't seem to come to a decision across differences. You each are working in organizations, be it religious or social organizations, in which you are advocating for the rights of persons for whom other persons strongly disagree with you in the advocacy for those rights and think certain persons don't have a right to be treated as sacred human beings or whatever. How? But you need those other voices if you're going to get something done. This, what we're seeing on Capitol Hill shows that. How do you lead across differences? Danielle.
I just want to say this is part of my outside life, not at Children's Rights. I just want to say that we talk about that only when Democrats are in power. We don't talk about that when Republicans are in power. And I know we're all 501c3s, and I probably shouldn't have said that, but I think that, we talk about reaching across the aisle and how important bipartisanship is, and et cetera, et cetera. But we are the ones, it's the people on the left who talk about that. It's not a topic that comes up on the right. And I really did step out of bounds there. And I'm sorry if I offended anybody.
I don't think so. but yeah, and that notwithstanding, and you're right. But somehow, or you're correct, because we don't want to say you're right. You're correct, but somehow we've got to figure out how to do it. And you all have been successful in the work that you're doing. So you figured it out in some way. How do you do it? Patrick, you're going to teach a course on that, so I'll jump in.
Well, I will say that this polarizing discourse, right? It's interesting that I think this is something where the Episcopal Anglican tradition has something to teach us about, right? Deconstructing binaries, right? The whole Anglican tradition comes out of the Catholic and the Protestant synthesis. And that's quite frankly at the heart of queer theology. You think about queer theology and you think of all these things, but it's really about deconstructing the binaries, saying that you have male and female here and the two shall never meet, right? Challenging those. And I think it's a framework of thought. And I think, trying to get people there is going to be a challenge, but we'll never get there if we're not able to have some basic conversations. And that's why I think in the public square, I think we need to resurrect the discussion of theology, because I think that has something to teach us.
And it is, and I see Danielle wanted to jump in. I'm going to add one little piece of this, and Stan and Danielle jump in. And is there something that, if we're going to talk to people who disagree with us across the differences, is there something that we at least have to agree on, right? And, like I like to say, well, before we can get into this discussion, we've got to at least agree on people's basic humanity. Is there something like that we have to agree on? Stan, you've been trying to jump in.
Yeah, could we make it as simple as just adhering to the golden rule? You know, I mean, can we make it as simple as the right to swing your fist stops at another person's nose, right? You know, so like that great, go for your religious freedom, but that doesn't mean that you get to legalize discrimination when it hits someone else.
Good.
Especially when you're using taxpayer funds to do so. But I would like to add here that, you know, Children's Rights does a lot of litigation on behalf of children in juvenile justice and child welfare systems. And we negotiate all the time with the other side. We have a lot of different settlement agreements that we monitor. And I think that it's because there's a principle there of what's in the best interests of the children. And as long as that I'm back to the Fulton case, as long as we are talking about something that is not taken into account, then I don't know. I mean, if we can negotiate with our defendants all the time, you would think that most people would be able to. And I hope that there's a way, whether it's theological or legal or some other way, but I think that things have gotten very polarized. And in order to do that, both sides need to work on it. Not
Thank you for that. And I'd like where you said you raised what's in the best interest of the children. And here's what we know. Our children are the most vulnerable, right, in our society. And that somehow, if we're going to think about justice, that we have to think about that in relationship to our children, in relationship to the most vulnerable. And there are certainly no children that are more vulnerable in many respects than children, LGBTQ plus children. And then we can add the other factors of children of color that are LGBTQ, et cetera. But we're talking about those who are the most vulnerable. And if we can keep them at the center and at the beginning, perhaps, then we can begin to apply the golden rule. So it leaves me to ask you each this final question. And that is, even as we go through Fulton and many more cases that will come before us, what, at the end of the day, would you say, if you close your eyes, that a just society looks like? And what do we need? What one thing would you say we need to get there? Stan.
Oh, God. Well, in a largely Christian nation, we need to adhere to the true spirit of the gospel. These arguments are coming from Christian right, you know, and for me, the core of the gospel is about justice. So.
Thank you. Danielle, would you like to answer that?
Well, I was going to quote something that Fred Davey said on a panel we had, Children's Rights hosted about Fulton. And what he said was that by supporting taxpayer-funded discrimination that harms children, these groups abandon the primary tenets of their faiths because they don't do justice, love mercy, and walk humbly. And I'm not the theologian on this panel, but I would say that we must put our children first in every way, whether it's in educating them, funding their sports and their music and their arts and everything else, regardless of their color, regardless of their sexual orientation or gender identity. We must affirm our children from the second we decide to have them.
Thank you, Patrick.
I think for me, I love the Micah statement, and I think the notion of the kingdom of God, the kingdom of heaven. And I'm speaking as an Episcopalian, as Christian, but like when we pray, "Thy kingdom come" in the Lord's Prayer, the kingdom is, or the reign of God is one in which the least among us, right, is a reversal. And I think that is what we really need to remember, that we are only as good as how we treat the least amongst us in our society, whether that's Matthew 25 or the Lord's Prayer. And I think we need to have a conversation about that. And that is why I think prophetic, not just prophetic Christianity, but Christianity that is true to the teachings of Jesus really requires us to look at the least amongst us. And that's what I think we need to have a just society.
It puts in a different perspective the quote from Jesus, the saying from commandment from Jesus, if you will, that a little child shall lead. And certainly it will be children that will lead us to a more just society, if but we would do right by our children. I want to thank wholeheartedly each one of you for joining us in this very important conversation that is only the beginning of conversations that we must continue to have. And I know there are many questions left unanswered, and that I hope people continue to pursue those and continue to pursue this fight for a more just society, which certainly begins with the most vulnerable of those who are our children. And I would be remiss not to thank those behind the scenes who have made this possible. I thank Ian Rees, who is working his magic behind the scenes in terms of this production. And I must thank, and can't thank enough, the executive director of the Anglican Studies program, Miguel Escobar, who has kept us fully engaged and fully apprised and involved in these struggles, particularly in our partnership with children's rights. So I thank them, and I thank each of you who have joined us in this conversation. And I invite you to continue to partner with whomever it is in your community to move us toward a more just society, and keep your eye on the prize of things like the Equality Act, and do all that you can to make sure that there will be equality for all in this nation. Thank you.
Thank you.
Thanks, Kelly.